Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a warm hello to everyone in between. My name is Dan Balkaran, as you can see on the screen, and I'm going to be your employment lawyer for the next 30 minutes. I am an associate. I'll be answering all your questions employment law. I am an associate at Samfiru Tumarkin LLP, which is Canada's leading employee side employment firm. And as always, you can get a hold of us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, so we've got one question that has arrived already, but please don't hesitate to send your questions in. Last session I had with you 2 weeks ago, we had just a tidal wave of great questions, and certainly hope to get those again today. So let's just dive right into it. Jessica asks, I feel like I'm being forced to quit my job because of my new manager won't honor my original work schedule, which allows me to get my kids to and from school and daycare on time. So, okay, so Jessica, it can schedule changes. There's two pieces to your question here. So, schedule changes where, especially where your employer knows about it and you've been working under that schedule for a substantial amount of time, where they have changed your schedule in such a way that you can no longer retrieve children from daycare and take care of your kids as you've scheduled and indeed bargained for. That can amount to a constructive dismissal because you don't have a choice, right? You can't not pick your kids up from daycare, right? And so usually in these situations, the best solution is amicable. And if you can work it out with your employer, that's great. But if you can't, and you obviously can't negotiate retrieving your children from school or from daycare, it may be that you have to quit, but you can do through a lawyer and claim constructive dismissal. Schedule hours and schedule changes are tough ones for constructive dismissal. And so let me explain what constructive dismissal is. So if you are terminated without cause, you get severance. Now, your employer has not terminated you. However, there is such a thing called constructive dismissal, which most of us have heard of, where most people have heard of, and that's just where the actions of the employer are tantamount to a dismissal. So the employer, through its actions, has indicated its intention to effectively not be bound by the terms of your contract of employment. Now, whether or not you want to do that to trigger a constructive dismissal or not depends entirely upon what your potential severance is, how much you need the job, how flexible the job is with your arrangement with your children, et cetera, and what your employment contract says. If your employment contract limits you to employment standards, the Employment Standards Act minimums, so say 4 weeks or whatever it is that you have coming to you, you probably don't want to trigger your constructive dismissal. But if you have 10 months of severance potentially coming to you, then you may. But the constructive dismissals are difficult because you have to get a court to agree effectively, if it comes to that, that the actions of the employer were tantamount to a constructive dismissal. And especially if your pay has not changed, that can be difficult. It creates more risk for you in the process, because if you get it wrong, you quit. And if you get it wrong in litigation, if you're in superior court, there could be cost consequences attached to that, which means you'd end up owing money. So you have to be right about it. Okay. And certainly, if you were working 8 to 4, so you could retrieve your kids, and now you're being forced to work 9 to 5, and now you can't retrieve your kids from daycare, that's obviously tough from the perspective of it's only an hour shift, but at the same time, you have no choice, right? And so I actually haven't looked into, because you can't negotiate retrieving your kids from daycare, and so I haven't actually looked at the law on that with respect to retrieving children from daycare, but it feels like that is probably a constructive dismissal. Either way, you're going to want to talk to an employment lawyer before you do anything. And of course, if you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca. and 1-855-821-5900. Second component I want to say about this is if the employer, through its actions, the employer can't discriminate against you on the basis of family status. And so it is, in this case, family status is really hard to make out. The discrimination has to move from the employer. It has to be a change that they made to your existing situation, not something that you wanted or requested. And you were working Schedule A, and now you're working Schedule B. It's very, very possible that is also runs afoul of the human rights regime wherever you're located, and you would have a potential human rights complaint as well. But also, family status is very narrowly defined, very hard to make out, but it is potentially there, and you could sort of pair it in tandem with your wrongful dismissal claim for more value. But just a note on that: if you do trigger your constructive dismissal, you don't have a job, you're not working there anymore, you're done, right? And so, especially if you've got kids, you've got dependents, which obviously you have. Maybe that not having an income stream for a little while you sort out your claim, it might not be something that you can afford, in which case, as I said before, that the opening of when I was answering your question, probably the best solution is amicable. If you can work this out with your manager or the organization in general, that's probably the best solution for all parties. So I'll leave it at that. Certainly, before you do anything on a constructive dismissal front, you need to talk to a lawyer to assess in fine detail your specific legal position. But yeah, I maintain that if you can figure this out with your company, that's the best solution. Okay, I don't know who this is. Hold on, Jessica has one more follow up. Boss says that your set schedule isn't in your contract, so she doesn't have to honor it. I asked to have my contract changed, but no one is working with me. What should I do? Okay, well, we already addressed that. It doesn't matter if it's, most contracts don't. I mean, some do, but most employment contracts don't have the schedule written down. So it was understood that you needed this time off for retrieving your kids from daycare every day, and that's what occurred every day for a year or two or whatever. And then they decided to change it. Everything that I just said still holds. So it sounds like it's not going to be resolved through negotiation, but it certainly, that is still your best option, I think. But failing that, definitely talk to a lawyer. Give us a call, 1-855-821-5900. Okay, moving on. I don't know who this is. They didn't leave a name, but in August last year, I told my manager that I intended to retire. Never do that, by the way. If you want any severance claim, potentially. She emphatically asked that I stay on, insisting that I could work from home full-time, which I've been doing since then. I recently received a new hybrid work-from-home policy from HR stating that we are to be in the office 3 days per week. This is not possible for me as I've moved away, and your employer knows this. My manager has said to not worry about this, but how should I respond to HR? Well, it seems to me in this situation, you have all the leverage, right? This isn't really an employment law issue. This is just an employment issue, right? Like, you don't care if you work or not, right? You've already retired. You're doing them a solid because they need you. So, you can just say, listen, I'm working from home and that's it. If you don't like it, lump it. I'm not working anymore, because you don't care, right? You've effectively retired, or you're content to retire. I think this is not your problem at all. I think this is the manager's problem. And I think that you need to tell your manager, listen, I've moved. I told you I was going to retire, and I can't come to the office. I'm not going to come to the office. I'm doing you a favor by continuing to work. I'm only going to do that remotely. This is what HR sent me. Can you please address this? I don't want any part of this. Okay. And just put the ball in your manager's court. And like I said, you're playing with house money. If they don't sort this out, you're retired. Right. But I mean, I can see all kinds of solutions. You work 2 days a week from home, and that's it. You just continue to work from home. Honestly, this HR policy is probably something, the way, I don't know how big your organization is, but comes from on high. People are still trying to figure out, businesses are still trying to figure out, like, what kind of office footprint they want to have, right? And I used to be an employer, and I totally get it. Having people work remotely where you can't instill culture into them, you can't maintain camaraderie to the same degree, you can't monitor productivity, that can be a problem over time. And so you want people in the office, but at the same time, with people working from home on a rotation, you save huge amounts of money on office space, and plus people, quite frankly, employees just said, what, I like this flexibility. I like the fact that I can work from home and I can move my schedule around and deal, more effectively deal with my, it's a bad way to say it, able to change my schedule in such a way with this flexibility to be able to assist or retrieve my kids from daycare, you spend time with my children or whatever it is, right? And so the hybrid model seems to be here to stay, but there's a balancing that's going on, I think, for lots of employers. And if the boss, the CEO decides that, then HR has got to execute and send it out blanket across the board. But it doesn't mean that they're not going to have grandfathered exceptions like you. So I personally believe that this is not your problem. A, you're playing with house money because you don't care if you retire, and B, let your manager deal with it. Jared asks, I was let go after almost 3 months and given just 2 weeks of severance. I know this was technically probation, but I was given no indication that I wasn't doing my job well. Do they owe me anything else? Depends what's in your contract, and if you're provincially regulated or not. I'm not familiar with federally regulated federally regulated employees, what the period of severance notice required if termination in the first initial phase is, unfortunately. But generally speaking, Employment Standards Act, if you're provincially regulated, which 90 to 95% of you are, you don't get anything in the first 3 months. Two, most contracts also cover that off as well. They gave you 2 weeks to sort of make sure that you don't bring any claim against them. If your employment contract, but actually, Joe, it depends what's in your employment contract, right? So if your employment contract doesn't, hold on a second. If your employment contract doesn't attempt to contract out of the common law presumption of common law notice at all, then you'd be entitled to more, because short service employees, which you qualify for, can get upwards 2 to 3 month floor, and they can get more from there, right? And depending on how long you've been unemployed for, and so I think it's probably worth it for you to. I mean, I don't know what's in your contract, but it's probably worth it to kick the tires on it. Talk to an employment lawyer. If you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Jared, for you, whether or not it's worth it also depends on how much income you were making. So, I have files where, guy or, the employee was gone after 3 months, 4 months, 2 months, whatever. But if they're making 150 grand a year, then that can have significant value. So, whereas if you're making 45, it has less value. But I would talk to an employment lawyer just to find out what your employment contract says. If it limits you to the Employment Standards Act minimums, or sorry, let me rephrase that. If it does contract with the presumption of common law notice, you're probably out of luck. But worth it to kick the tires on it, because if it doesn't, then you get common law severance, and that's certainly more than the 2 weeks they provided you. You'd mentioned, do they owe you anything other than that? There are some cases out in Ontario. I'm not really familiar with them. I'm not sure if there are in BC that talks about how termination needs to be more. If it's a termination during the probation period for no notice, there needs to be sort of a proper consideration of the employee's abilities or fit, we'll say. I'm not familiar with that, but there is a line of cases about that. I think that would be I'm not sure if they're in BC, and B, I think that would be a tough road to hoe for sure. So, but anyway, I think it's worth it talking to an employment lawyer just to see if there's any value there, depending upon what your contract says. Donna asks, employer said they're letting my contract go, but when hired 2.5 years ago, there was no contract. I had no verbal no written, nothing. I don't have enough information, Don, to answer your question. It sounds like you're getting terminated. It's not. It sounds like you were an indefinite employee, which means you'd be entitled to severance. It sounds like you don't have an employment contract. If that's all correct, then you certainly have you have a severance claim, and you should contact an employment lawyer immediately. Sound like a broken record, but you should, our information, if you want to get a hold of us, employmentlawyer.ca, helpinemploymentlawyer.ca, 1-855-821 5900. So, but Don, I don't have enough information there to be able to answer your question properly. Tanya asks, if constructive dismissal is necessary, what steps do you take? So I covered this in detail earlier in the program, and certainly I'll be posting this on we'll be posting this on our social media page, and I'll post it on my LinkedIn afterwards. But just sort of broadly speaking, constructive dismissal is harder certainly because than a normal severance evaluation. Because even if before you get to the severance evaluation, you need to convince a court that the actions of the employer repudiated your contract of employment. And so effectively they through their actions, they have demonstrated that they don't want to be bound by your contract of employment. And so I'll give you some examples. The best way to get there is if they reduce your salary or hours, and therefore your salary. There's some case law that talks about it being 10%. I would have some concerns about 10%, but certainly if they reduce your wage by 30%, that's, you're not supposed to, you can't take a 30% pay cut, right? And so if they unilaterally impose the 30% pay cut on you and you reject that, effectively you are constructively dismissed at that moment because you've rejected the pay cut. But you only have, it's very important, you said what steps to take. You need to talk to a lawyer immediately before you do it, because you have 2 to 3 months in BC. Just generally actually in Canada, you have 2 to 3 months, but you have 2 months certainly, but there's a BC authority that stretches it to 3 in certain circumstances. But if the employer imposes a change to the fundamental terms of your employment upon you, so salary being one of them, you've got a certain amount of time, but it's a short time, to try on these changes and then reject them. And if you don't, so say you just work under the pay cut for 4 or 5 months and then you try to reject it, you'll be out of time. The court will say, well, no, you're deemed to have accepted it because so much time has passed. So that's one example. Another would be, and this is harder, okay, it is if you were demoted or your position was hollowed out. So, for example, you were manager of customer service and now you are the janitor. That's absolutely a constructive dismissal. But what if you were the manager of customer service and your title stayed the same as manager of customer service and your salary stayed the same, but now instead of managing your teams of employees, you're just off in a cubicle by yourself doing nothing, right? That happens, and is that a constructive dismissal? Probably, but you've got to get there on the facts. And constructive dismissal depends on the judge has to like you, and certainly depends on the facts. But the tough part for any evaluator, any adjudicator is, well, listen, your wage was unchanged and your title was unchanged, so how is this a constructive dismissal? And so the courts have acknowledged time and again that we derive more than just pay from our jobs. We see our coworkers and we're at work often more than we're around our loved ones, and therefore we derive a certain amount of emotional satisfaction from the job, that if your authority, your position is just hollowed out completely, that in fact can be a constructive dismissal. So these are different ways you can get there. Also, if you're experiencing ongoing documented harassment, particularly if it's a human rights, it also infringes on a human rights protected ground. Like if you're experiencing sexual harassment, that can get you there, and you've put the employer on notice. Hey, this is happening. Please stop it. And they don't stop it. then certainly, or take any corrective or remedial actions, that could be a constructive termination as well. But with those are really hard. So many people come to me and say, I've been bullied. It's a constructive dismissal. Well, the courts aren't going to criminalize. It's a bad expression, but you get what it's socially criminalized. We'll say, commercially criminalized. Disagreements or disagreements between sort of workers and their bosses, or just a sort of the friction that comes in a hierarchy. The courts don't want to do that. So you if it's bullying and harassment that gets due to constructive dismissal, you better have a lot of evidence, and it better be really serious. Otherwise, you're just effectively quitting. And remember, if the other side, in a constructive dismissal, if the other side gets a lawyer, which they almost always will, the lawyer has every incentive to push that thing closer to a trial because of the risk you have. If you get, it's a fatal issue in a case, right? If you claim constructive dismissal and you're wrong, you effectively quit and you get zero. But if you're in superior court, you also have to pay the court costs of the other side. So you could owe money. So it's very serious. And so anyone listening to this, anyone who is thinking about claiming constructive dismissal, you need to talk to a lawyer before you do anything. So number one, you've got a finite amount of time to pull the trigger on your constructive dismissal, a couple months from the termination. So talk to a lawyer right away. But number two, you can't do it on your own. You can't just especially with constructive dismissal, you can't just say, okay, well, I quit then, and then try to get a lawyer to clean it up afterwards, because you might have gotten it very wrong, and it might be that it creates too much risk for you. So if you need to get a hold of us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But Tanya, if you take anything away from this segment here, talk to a lawyer immediately. Jay asks, an employer of mine has eliminated my position within the company, has offered other work within the company. If I were to give it a shot, how can I ensure that I still have severance rights if I find the new position is not for me? So, does the position pay you the same and has more or less the same role or same level of authority? Right? The question is, if you're effectively fired, right? Are you required? So I'll back up here for a second. Your right to common law severance, and I don't know if you have that right. Your right to common law severance is not unfettered. Okay, it's subject to you making reasonable efforts to look for replacement employment. And so if you turn down a position that is comparable in terms of your wage, skill set, experience, and compensation history, it could be that your severance claim is stopped out right there. It could be. It depends on the situation, right? If it's materially different in some way, then no. So that's the fundamental question. And if the answer is, it's a totally different position, pays different, all that stuff, no, you don't have to accept the job. Now, but your question is, if you accept it, is your severance still preserved? Now, I had a file about this fairly recently. I had a client who had this situation, and there's only a couple cases in BC on this one. It's sort of split, and one of the authorities is very old. If you accept a new position, can you then claim constructive dismissal afterwards? And so one case says no, because you've accepted the new position. And the other case says yes, because you were mitigating your losses by working the new job, but you were still trying it on within the 3-month period. And so if you accept that role, it could be, and then you try to claim severance later, you could be looking at a haircut of up to 50% if you get a negotiated solution, or even a tougher situation if the employer is aggressive, which some employers very much are with their employees. So I don't like that at all, that particular fact pattern you're talking about. But I think the more important question is, are you obligated to accept the offer of the new job they've put in front of you? Because you might be, right? So Jay, I think you need to talk to an employment lawyer right away. You can get a hold of us, employmentlawyer.ca, helpemploymentlawyer.ca, 1-855-821-5900. Dean asks, I'm returning from disability leave, but unsure if my boss is willing to let me work a new schedule. I can no longer work full-time hours. I'm getting a lot of pushback. What do I do here? Well, I assume you're working with some sort of occupational health and safety. If you're on disability, did the disability occur at work, and therefore you're working with an occupational health and safety governmental body? Or if not, you were just on medical leave, but you had insurance. So I need to know that, but you had insurance covered long-term disability, we'll say, most likely. And so now you can only work at sort of reduced hours or with physical limitations and so forth. Your friend here, Dean, is your doctor. Okay, so core part test here is that your employer needs to accommodate you to the point of undue hardship. Okay, so you need to get your doctor's note saying this is what Dean can do and what he can't do. You need to provide that to your employer, and they need to accommodate you. If they don't accommodate you, uh, in that they might not let you work, for example. Um, they might not have a position for you. Then you've got a human rights complaint, and you may even have a constructive dismissal. Gets a little complicated. These are complicated cases, but it sounds like if you can work at 70%, or the doctor says we'll put you on a gradual return to work over 6 months. You need to paper that properly with all the medicals, put that in front of your employer, and let your employer try to scramble around and figure that out. If your employer doesn't let you return to work at all, okay, that's effectively a termination at that point. And then you have a severance claim, but you might not want that. Your severance claim might be small, depending on what your employment contract says. Or you might, this is the job for you, and you've been in it for a long time. It might be something that's just not a tenable solution for you. You can also bring a human rights complaint while you're still an existing employee, although it tends to poison the well a little bit with your employer, and they may not want to continue. They may not want you to continue sort of long term after that, although they're not supposed to be able to punish you for reprisal. But I would definitely I would get everything properly papered from your doctors, see what your employer does, and then if there's no effective solution provided to you, you should talk to an employment lawyer right away. I know I sound like a broken record, but you can contact us, employmentlawyer.ca, helpemploymentlawyer.ca, 1-855-821-5900. I just want to see if there are any other. Oh, there are a lot of questions. Hold on, let's see if I can scan through these quickly. Tanya again, if losing wages due to accommodation, would that be a constructive dismissal? Well, depends on what the accommodation is for. If you can only work at 70%, so they put you in a reduced role, maybe not. They just have to. It sort of has to be a reasonable accommodation. I don't really know what that's for, Tanya. JR, are there any particular legislation regarding privacy via communication line during an employment telecommunication engagement? I don't really know what you're saying, but yes, there is privacy legislation that exists that protects certain aspects of your employment. I don't know what that's referring to. Like, are you talking about Zoom and so forth? Join us again on Monday. Sorry for Chris Justice on March 20th. He'll be at 1:30 p.m. Eastern time. He'll be answering all of your questions, employment law. Listen, I'm going to have to end it there. I'm sorry. I know Jay and Tanya have follow-up questions, but it looks like we're out of time. So I'm just trying to see. There's one more question that I'd like to answer if possible. Daryl asks, I've had my supervisor reduce my job duties as a form of punishment for disagreeing with him. After reporting this, I was allowed to perform those roles again. He has recently done this again to me. Well, it sounds like you and your supervisor are not getting along. So at some point, I don't know how that's going to be a tenable relationship across time. But this entire Facebook, it's a bad expression. This entire video stream, we have talked a lot about constructive dismissal. If they have hollowed out your duties, it could be that you have a constructive dismissal claim. But if you reached an amicable resolution with your employer by reporting it before, an amicable solution is what you want here most likely. However, if you can't find one, it could be the reduction in your duties of constructive dismissal. So I would encourage you, one, go watch this entire video again because I covered it in great detail, and two, speak to an employment lawyer. Again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, lots of great questions today. Thank you very much. We went a little long. Everyone have a wonderful and safe weekend. I'll be back in 2 weeks, Friday, same time. I look forward to seeing everybody then. And of course, please join us on Monday at 1:30 p.m. Eastern Time with Chris Justice, answering all of your questions in employment law. Other than that, have a great weekend.